Hello everybody, welcome to iExamB's Legal B. This is Amrita, your law faculty at iExamB. Legal B is a very nice initiative by iExamB for covering all the law examination, preparation content, strategic videos, exam updates and whatnot. So don't forget to subscribe to Legal B and stay updated. And also we have recently started with a series for Judiciary Mains answer writing preparation. This is the third video of the series. Every day you will be getting a discussion on question and answer. One question we will be picking up every day. So आप stay tuned रहिए and हर दिन एक नया आंसर, एक नया क्वेश्चन, एक नया टॉपिक आपका रिवाइज हो रहा है from different सब्जेक्ट्स. So this is a very beneficial series. Don't miss it. अगर आपकी कोई भी क्वेरीज हैं या फिर आपको किसी क्वेश्चन पर आंसर की रिक्वायरमेंट है, यू कैन राइट टू अस इन द कमेंट सेक्शन ऑफ दिस वीडियो ऑल्सो, और यू कैन ईमेल अस at hello@exambi.com. You can also call on this number. Visit our website for more details relating to exam preparation courses available at iExamB. Judiciary Mains answer writing practice series that we have started. In this question number 3, I'm going to discuss with you all today in this video. And that is going to be a very important topic from Code of Civil Procedure. And the question is, explain constructive res-judicata with aid of suitable illustrations. इस पर आपको एक मेंस का अगर आंसर लिखने के लिए आ जाता है तो आपको इस क्वेश्चन को कैसे टैकल करना है. फर्स्ट ऑफ ऑल, ट्राई टू अंडरस्टैंड द क्वेश्चन वेरी प्रॉपरली. Be careful while reading the question. They have asked you constructive res judicata. Everybody knows about res judicata. It is incorporated under section 11 of CPC. So आपको introductory part में उसके बारे में add करना ही होगा. This is something which we have to understand while we are framing the answer. Okay, so let us see a sample answer for our understanding. First, you have to start with res judicata. What is this? The doctrine of res judicata. It is incorporated in section 11 of CPC. No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them litigating under the same title in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. So res judicata doctrine का पहले मतलब हम लोग समझ लेते हैं. What does this mean? This is actually a universal doctrine, not only in our Indian laws but also it is applicable at the international level. ये एक international law का part है. At the same time municipal laws में भी incorporated है ये doctrine. So res judicata का मतलब क्या होता है? That when any particular case has been decided and that case is between same parties, the cause of action is same, and one more requirement is that the parties are litigating under the same title. That means what? Plaintiff is plaintiff and defendant is defendant. अगर ये टाइटल इंटरचेंज हो जाता है कि प्लेंटिफ डिफेंडेंट की जगह पर आता है, डिफेंडेंट प्लेंटिफ की जगह पर आता है अगले सूट में, तो वो नेक्स्ट सूट रेस जुडिकेटा से बाहर नहीं होगा. लेकिन अगर पार्टीज सेम टाइटल के अंडर लिटिगेट कर रहे हैं, प्लेंटिफ इज अगेन कमिंग एज प्लेंटिफ अगेंस्ट द सेम डिफेंडेंट ऑन द सेम कॉज ऑफ एक्शन बिफोर द कोर्ट हैविंग सेम jurisdiction, then res judicata doctrine will bar that suit. That means कोर्ट का टाइम आप दोबारा उसी पॉइंट पर वेस्ट नहीं कर सकते. जो डिसीजन है वो आप पर बाइंडिंग होगा. That has to be maintained. You can go in appeal, you can go in revision to higher courts, but you cannot go in the same court with the same jurisdiction again to try that particular matter. That is a bar which doctrine of res judicata applies. So now what is constructive res judicata, which is the main crux of a question. Constructive res judicata is also covered by the same section of CPC, section 11 only. It applies when the matter is directly and substantially in issue in a suit, has also been directly and substantially in issue in a former suit between same parties, and such matter has been heard and finally decided in that former suit by a competent court. कंस्ट्रक्टिव रेस जुडिकेटा पर रेस जुडिकेटा के सारे प्रिंसिपल्स अप्लाई तो होंगे ही, बट वी हैव टू गो अ लिटिल बिट एक्स्ट्रा. मीन्स वी हैव टू अंडरस्टैंड दैट व्हाट इज समथिंग विच इज पर्टिकुलरली और विच इज peculiar in constructive res judicata. A matter directly and substantially in issue may be so either actually or constructive. A matter is actually an issue when it is alleged by one party and denied or admitted by the other. Now, what is the thing that we need to focus on over here to understand constructive res judicata is that the matter that is directly and substantially in issue is what we have to check to see whether res judicata doctrine is applicable or not. तो अगर आप मैटर को देख रहे हो कि वो डायरेक्टली और सब्सटैंशियली इशू है या नहीं पिछले सूट में, तो आपको ये भी चेक करना होगा कि वो मैटर एक्चुअली इन इशू था या फिर कंस्ट्रक्टिवली था. यानी कि रेस जुडिकेटा डॉक्ट्रिन को काफ़ी ब्रॉडली एप्लीकेबल किया गया है बाय इंक्लूडिंग कंस्ट्रक्टिव इश्यूज एज वेल. यानी कि अगर आपने एक्चुअली वो मैटर रेज नहीं किया था but you were having an opportunity to raise that matter in the previous suit but you did not take that opportunity, then it will be amounting to constructive res judicata and your matter will be deemed to be decided on that particular point. Please note these words that I am mentioning you. चाहो तो आप वीडियो को पॉज करके रिपीट रिवाइंड करके वापस सुनिए जो मैंने अभी कहा है. That is what is the concept of constructive res judicata. So like this your answer should have a flow starting with res judicata, the section, and then coming to the crux, it is constructive res judicata, what it is. Explanation 3 and 4 of section 11 will be relevant for you over here. There are many explanations in section 11 but आपके आंसर के लिए आपको जो relevant है आपने वो ही पिक करना है. You don't need to pick the rest of the explanations. अगर आपका क्वेश्चन सिर्फ res judicata पर होता then you would have done that, but for constructive res judicata you have to just pick the relevant section explanations. Explanation 3 says that the matter in issue should have been alleged by one party or denied or admitted expressly or impliedly by the other party. यानी कि वो इशू पहले एलेज किया जाना चाहिए और अदर पार्टी ने उस इशू को आइदर डिनाई करना चाहिए या फिर एडमिट करना चाहिए. दैट डिनायल और एडमिशन कैन बी दो एक्सप्रेसली और impliedly done by the other party. Explanation 4 says what? Section 11 explanation 4 says that by deeming provision, it is actually a deeming provision, this constructive res judicata. Deem means you are assuming that thing which is actually not happening. Actual means actually that was raised, then that is actually you are applying res judicata. But if you are deeming that, that means there was an opportunity, you did not take that opportunity, so it is your fault. So that is what is known as deeming provision. It lays down that any matter which might and ought to have been made a ground of defense or attack in the former suit, but which has not been made a ground of attack or a defense, shall be deemed to have been a matter directly and substantially in issue in a suit, in such suit or a former suit. That means such kind of issue shall be deemed to have been made. Constructive res judicata में deeming provision होता है. What are the conditions requisite for res judicata now? Let us see that as well. All these conditions requisite will be applicable for constructive res judicata also. That means the matter you are checking in issue should be directly and substantially in issue in the subsequent suit and should be covered in the former suit as well. And the matter should be same and it can be actual also, it can be constructive also. The former suit must have been a suit between same parties, जैसे मैंने आपको अभी बताया, and it should be between the same parties litigating under the same title also, and such parties must have been litigating under the same title in the former suit also. अगर उनका टाइटल चेंज हो जाता है, जैसे मैंने आपको कहा प्लेंटिफ डिफेंडेंट बन जाता है, डिफेंडेंट प्लेंटिफ बन जाता है, that is not a problem. The court which decided the former suit must be a court competent to try the subsequent suit. That means the jurisdiction of both the courts should be equivalent. If suppose it is a higher court where you are going, then that will not be barred by res judicata because the jurisdiction is higher. You are going either in appeal or in revision. then that's not hit by res judicata doctrine. And the matter directly and substantially in issue in the subsequent suit must have been heard and finally decided by the court in the former suit. Matters should be decided, ये भी एक important point है. Now discussing some case laws as well, as the question mentions about suitable examples. So there is a famous case law on the point, Workmen of Cochin Port Trust versus Board of Trustees of the Cochin Port Trust, year 1978. In this case, doctrine of res judicata was discussed. It is covered under section 11 of CPC. When does section 11 come into play? It comes into play only for civil cases. And the constructive res judicata rule is also incorporated under section 11 explanation 4 of CPC. If by any judgment or order any matter in issue has been directly and explicitly decided, then the decision operates as a res judicata and bars the trial of an identical issue in a subsequent proceeding between the same parties. So this was discussed in this workman's case as well. Principle of res judicata comes into play if any decision is implicitly covering any particular issue or any matter in issue which might or ought to have been raised as a ground of attack or a defense in an earlier suit. This is the concept of res judicata that is discussed in this particular doctrine, that any ground which might or ought to have been discussed earlier in the former suit, but it was not discussed, so it will be deemed to have been discussed, and that is what is the simple concept of constructive res judicata. Another case is the case of State of Uttar Pradesh versus Nawab Hussain, AIR 1977. In this case, SC, it should be SC 1681. This case is relating to dismissal of services of a sub-inspector of police that was done by a DIG. For this, he had gone in writ petition. He filed a writ petition to challenge the dismissal of his services. In that, state contended that the suit was barred by constructive res judicata because earlier he had gone in a civil suit as well. So the trial court, that is the first appellate court as well as the high court, held that the suit was not barred by res judicata. But then afterwards again he went and appealed to the Honorable Supreme Court of India, and the Honorable Supreme Court held that the suit was barred by constructive res judicata. So in this case also constructive res judicata was discussed and made applicable. Because in this case, particularly if you can check the facts also and try to include the facts also in your answer. If you are able to include it, it's well and good. In short, in your answers, then your answers will be more nicely framed. Constructive res judicata, as the plea was within the knowledge of the plaintiff and could well have been taken in earlier writ petition as well. So it was not taken. That pleading was not taken in the earlier writ petition. So it is barred by constructive res judicata. This was held by the Supreme Court. It was observed that when any matter which might ought to have been made a ground of defense or attack, either allegation by way of attack or a defense, any of the following things is made in a formal proceeding, or it is not made, it is not actually made but could have been made, then that is going to amount to res judicata, constructive res judicata. And to avoid multiplicity of litigation and bring finality to litigation, this deeming provision has been added, that is of constructive res judicata. This was actually discussed. The objective of constructive res judicata was also covered in this particular case. So this is very, very important. आप लोग इस वीडियो के डिस्क्रिप्शन में जाकर PPT को डाउनलोड करके रख सकते हैं for your reference in the future. These cases are also very important. Constructive res judicata has also been discussed in various other cases, out of which one more case we will be discussing, Ghanshyam Singh versus Har Pyare, year 1974. This is relating to execution of an eviction decree. Two persons had claimed to be legal representatives of the deceased decree holder. In that particular case, they were LRs. They were claiming to be LRs. The JD, that is the judgment debtor, specifically raised the issue that neither of them was the legal representative of the deceased. So the question was heard and finally decided by the executing court. It was held that said decision of executing court was a decree and would operate as res judicata in the subsequent proceedings, because that question was decided by the executing court relating to legal representatives of the deceased. So that is deemed to be a decree, and if it is a decree, then to that res judicata will be applicable. in the subsequent proceedings also. And it is covered under section 47 of CPC, that is questions to be determined by the executing court. That is the scope of section 47. An important provision from CPC again. Res sub judice is also one allied doctrine which you can correlate here, as it is covered under section 10 of CPC. It is doctrine that is incorporated in section 10. Res sub judice and res judicata are two different doctrines which are having just one slight difference, that res sub judice is applicable when the suit is pending in court, and res judicata is applicable when the former suit is already decided by the court. The only difference is that the former suit is pending, and when the suit is already pending and you are going to the court with another suit on the same cause of action, all the conditions will be same cause of action, same parties, same cause of action, same title, then that another suit will be barred, it will be stayed actually. And res judicata, we all know the concept, it is going to bar a further suit. Res sub judice doctrine, that is incorporated under section 10 of CPC, that also you can mention here in this answer to make it more comprehensive, that no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties, or between parties under whom they or any of them claim litigating under the same title, where such suit is pending in the same or any other court in India having jurisdiction to grant the relief claimed, or in any other court beyond the limits of India, established or continued by the central government. And this is not applicable to foreign courts, okay? Remember that. So this was all that I had to discuss with you all from the question relating to constructive res judicata, an important topic from CPC. And for more guidance relating to all these judiciary writing answers, stay tuned to Legal Bee. Every day you will be getting one question for discussion, and this is a very nice initiative, as every day you will be able to discuss and revise one concept from different topics. This is a very good thing to maintain continuity. So stay tuned, download these PPTs for your references as well, and if you have any queries, reach out to us. And also there is a free workshop at iExamB. It is an expert session with Robin Dutt sir, who is a senior counsel practicing at Chandigarh and Supreme Court, Chandigarh and Punjab and Haryana High Court and Supreme Court of India. So he is going to take a workshop at Legal Bee. So stay tuned, as he is going to answer all the queries relating to litigation, judiciary, ADA courses and whatnot. So if you have any queries, this is a very nice opportunity. So do find the link of this workshop in the description of this video and register yourselves immediately. And don't forget to subscribe to our YouTube channel. Prepare 50% faster with iExamB. Thank you.